Yes. Good afternoon, everybody, and thank you for joining us today for our November webinar. My name is Ana Maria Studer, and I'm the Advocate Support Program Manager here at Standpoint. My role today is to help facilitate the webinar. If you have questions due to the presentation, please type your question in the Q&A tab, or you can use the chat box. Jay will put the link of the chat box on the box on the side. Most of you probably already know about our organization, but for those that listen to this later and those that don't know, Standpoint is a statewide organization. We are a team of attorneys and advocates working to assist individuals who have experienced domestic violence, sexual violence, and trafficking when it includes domestic or sexual violence. We also provide assistance to systems professionals who work with survivors. We do this by facilitating trainings and answering calls through our action line. Examples of trainings we do are the annual new laws training throughout the state of Minnesota, the monthly webinars for advocates like the one we're doing today, and other trainings by request. Our action line is answered Monday to Friday from 9 a.m. to 4 p.m. and it's through our action line that our attorneys provide legal advice to survivors, and at advocates connect callers with resources, safety plan. We listen and help callers identify possible options and next steps to take. This webinar is being recorded, and you can check it out on Standpoint's YouTube page. The link to the recording will be also emailed out to Standpoint's Legal Advocates listserv after the webinar. Now I'm going to introduce our speaker today. That is Rana Alexander, our Executive Director here at Standpoint. Rana has worked in the domestic and sexual violence field since 1997. She joined Standpoint, formerly known as Battered Women's Legal Advocacy Project, in 2005. Ms. Alexander became the Executive Director in 2016. And as an attorney for their statewide organization, she provides legal advice and consultation to domestic and sexual violence victims, advocates, and attorneys on legal issues that affect domestic and sexual violence victims. Ms. Alexander also provides training and outreach to attorneys involving issues of domestic and sexual violence and the law. She is graduate from Northeastern University School of Law in Boston, Massachusetts, and received with distinction her Bachelor's of Science degree in psychology and a minor in women's studies from the Iowa State University. And I'm super excited to introduce our Executive Director, Rana Alexander. Welcome, Rana.
Thank you, Ana Maria. And some of you might see that Ana Maria is new here at Standpoint. I'm super excited to introduce Ana Maria as a new staff member here. So we are just blessed to have her, and I'm so excited. So thank you. All right, you guys. So I'm Rana Alexander. I'm here to talk to you today about firearm prohibitions. We'll talk about federal firearm prohibitions, and then we'll talk about state firearm prohibitions. And what I'm going to tell you is that federal firearm prohibitions are reasonably straightforward. State firearm prohibitions are extremely complicated and convoluted, and we'll talk about that. So let's start with state firearm prohibitions. My computer wants to work. All right. As some of you know, I like to build in various memes into my presentation. So I got a couple in here for you guys today. So we have the scary dudes from Ghostbusters. And it says, one says, I open gates to other dimensions for evil demigods. And the other one says, I help. And I feel that way when I talk about firearm prohibitions, that somehow I'm going into like an evil dimension and talking about it. All right, so first of all, let's talk about federal firearm prohibitions. And so under federal law, there is a statute that exists that requires prohibitions against possessing a firearm if one has a protective order they're a respondent in a protective order. There are a number of qualifications that need to apply. So before that prohibition comes into place, we'll talk a little bit about that. So first of all, you got to have a qualifying order. And in Minnesota, a qualifying order would be an order for protection. And we'll explain why when we get to this qualifying language that needs to be there. but an order for protection would qualify for federal firearm prohibitions. Harassment restraining orders, because of the language that's in the order, would not qualify. And domestic abuse, no contact orders, because of their language, also do not qualify. So it's only an order for protection in Minnesota that qualifies for federal firearm prohibitions. So what does qualifying mean? Well, you need to have some particular language and prohibitions, and you need to have a notice and opportunity to participate. And we'll talk more about what both of those things mean. Finally, the order needs to be against an intimate partner, which under federal law means spouse, former spouses, an individual who is a parent of a child of the person, or an individual who cohabitates or who has cohabitated with a person. So this is much more narrow than Minnesota's definition of family or household member. It doesn't include people who are related by blood. It doesn't include somebody who is pregnant and the respondent is thought to be the father. It doesn't include a number of different things, but the biggest one is people related by blood. So if you have a brother who gets an order of protection against another brother, federal firearm prohibitions would not apply, okay? Because they are not they don't qualify as an intimate partner under federal law. All right, so you gotta have a qualifying order. Qualifying means some specific language, and you gotta have an intimate partner relationship as defined by federal law. So the person has to receive, under federal law, they need to receive actual notice in which they've had an opportunity to participate. Well, what does that mean? So we have a couple of cases under federal law that have helped explain that. And United States v. Wilson says, at a meaningful time in a meaningful manner. Now, in that case, we had a defendant or a respondent who was pro se, and he had a conference in the chambers with the judge, and the petitioner was represented, so with opposing counsel. The judge explained the order for protection. The defendant agreed to the terms, and his conviction for the violation was upheld. So this was a case, this is a situation where the respondent agreed to the issuance of the order for protection in judge's chamber. And the 7th District or the 7th Circuit found that that was a meaningful time in a meaningful manner. They had notice and opportunity and upheld the conviction. And also, actual participation is not necessary. So the 9th Circuit said in U.S. v. Young that the statute only requires there is an opportunity to participate. So somebody chooses to not show up for a hearing and then says, well, I didn't participate, can't use federal firearm prohibitions against me. The answer is no, you had an opportunity and you chose not to attend, and that's cool, you can make that choice, but federal firearm prohibitions can attach if the proper language is in place. So simply not showing to a hearing is not going to protect one from firearm prohibition. Other cases, there's a lot on the federal side, very much in the Minnesota side, but a lot on the federal side. It doesn't require that evidence is offered or that witnesses are called. Service with the notice of a scheduled hearing, and then they inform the court that they settled. And it's U.S. v. Banks in the Fifth Circuit. They said that was fine. So you ask for a hearing, the respondent asks for a hearing, or the petitioner asks for a hearing. Hearing is scheduled. Ultimately, everybody settles. Firearm prohibitions under federal law still apply. A hearing was scheduled. Respondent didn't appear. A hearing was set for a particular time and place, and the respondent must have received notice of that particular time and place. All of those things, if they happen, that has been defined as through federal law to be an opportunity to participate, and the prohibition against possession of firearms has been upheld, or the prosecution of such has been upheld. All right, so now we know what the notice and opportunity is. But now the next question is what's that qualifying language that needs to be in the order for protection? So you have to do one thing from the first column and one thing from the second column. The order must do one of these two things. The first column, it either restrains the respondent from harassing, stalking, or threatening an intimate partner of the respondent or the child of an intimate partner or the child of the respondent. or it restrains the respondent from engaging in other conduct that would place the intimate partner in fear of bodily injury, or place the partner or the child in fear of bodily injury. So in Minnesota, that would be our no abuse provision, right? The first checkbox is that you are asking the court that the respondent not commit additional acts of domestic abuse, often referred to as our no abuse language. And so the no abuse language, that checks both of these. It checks actually both of the whole thing under number one, right? It restrains the respondent because they're not allowed to commit further acts of domestic abuse. So that would be harassing, stalking, or threatening, since domestic abuse includes threatening language, right? If somebody is making threats, that would be domestic abuse. Or it even also includes restraining them from putting somebody in reasonable fear of bodily injury. Domestic abuse includes fear of imminent physical harm. So the domestic abuse box, if the no abuse box is checked, then we've got column 1 covered. And then the column 2 cover includes a finding that the respondent represents a credible threat to the physical safety of the infant, partner, or child, or explicitly prohibits the use, attempted use, or threatened use of physical force against the infant, partner, or child. And again, the no abuse provision of the order for protection would, if that box is checked, would cover the second category. So there's often a misnomer. I haven't heard this in a little bit, but I've heard before that folks say if you have an order for protection without findings, that does not qualify for federal firearm prohibitions, and that is incorrect. It is one way to fill the second column to meet that requirement. However, explicitly prohibiting the use, attempted use, or threatened use of physical force, there is an or there, and the checking of the no abuse provision of the order for protection does satisfy that second category. If you think about harassment restraining orders, a harassment restraining order may satisfy the first category in restraining the respondent from harassing by checking the no harassment piece. However, nothing in the harassment restraining order ever talks about threats to physical safety in the granting of the order. And it doesn't ever, the harassment restraining order doesn't actually prohibit the use, attempted use, or threatened use of physical force. So it prohibits contact. That's what it prohibits. So that's why a harassment restraining order would not qualify under the federal firearms code. So we're talking about firearm prohibitions on protective orders, because you have to have a notice and opportunity to be heard. An ex parte order for protection does not qualify for federal firearm prohibitions. And it also does not include an ex parte order for protection that becomes final without a hearing. So one of the interesting unique things about Minnesota is you can get an order for protection, and if you only request a certain subdivision of relief, called sub 7 relief, a hearing is not automatically scheduled. If a hearing is, and that order could become final if no one asks for a hearing. If nobody asks for a hearing, and firearm prohibitions do not come into play in those circumstances, a hearing needs to be scheduled. Now, as we talked about before, if a hearing gets scheduled, you've now had opportunity to be heard, even if you come to a settlement agreement. So asking for the hearing, if ultimately a protective order issues, that's going to trigger federal firearm prohibition. As we talked about, it doesn't include harassment restraining orders. It is a prohibition on all firearms and ammunition. It lasts as long as the order for protection is in place. Once that order for protection either expires or is dismissed, then the prohibition goes away and the respondent can possess firearms again. And there is an exception under federal law for law enforcement and military personnel, and they are allowed to carry their department or government issued firearm. They're not allowed to carry personal firearms. It would prohibit them from hunting with a firearm unless they were using their department or government issued firearm to do that hunting and to make those decisions. But they do get to continue to carry their department or government issued firearm, and they get to take it home. So it's not that they have to, under federal law, lock it up at work. And according to Bolsick out of the Fourth Circuit, the respondent doesn't have to be told about the prohibition. We all have a responsibility to know the laws that govern us. And so you don't have to be told about the prohibition. All right, before we move on to federal firearms, what misdemeanor crimes of domestic violence? Do we have any questions? All right. I'm going to go with silence, means I have amazingly explained federal firearm prohibitions and protective orders to you guys. If you think of any, please feel free, chat it in, add it to the Q&A, let us know. All right, so under misdemeanor crimes of domestic violence, the federal statute says anybody who's been convicted of a misdemeanor crime of domestic violence is prohibited from possessing. So it needs to be a misdemeanor under federal, state, or tribal law, and it needs to have an element of the use or attempted use of physical force or the threatened use of a deadly weapon. And it needs to be committed by an intimate partner. So we have, again, that narrower language in federal law about current or former spouse, parent, guardian of the victim, or a person with whom the victim shares a child in common, or a person with whom they are cohabitating with or have cohabitated with as a spouse, parent, guardian, or a person who's similarly situated to a spouse, parent, or guardian. Okay, so again, it's a more narrow definition. It's not going to include people who are related by blood. And also it is not going to include people who have resided together no, it doesn't include that. It doesn't include folks who may have a child in common but didn't live with each other, right? This is often referred to as the dating loophole, because our definition of intimate partner does not include folks who were dating, but not living together. So they were in a significant sexual or romantic relationship. Okay, so that is not included in this definition. So what does use of attempted use or attempted use of physical force mean? So we had a United States Supreme Court case back in 2014 called Castleman. And Castleman said it means any offensive touching. So there are some states, this was not Massachusetts, but I know that in Massachusetts, they follow a very common law definition of assault and battery. So a battery in Massachusetts is any offensive touching. So if you just touch somebody, you don't hurt them, you don't cause pain, you don't leave a mark, you just touch them, they didn't want to be touched, it is a battery in the state of Massachusetts. That's not true here in Minnesota. You need to have caused some sort of pain or to be able for it to be an assault, is what we would call it here in Minnesota. Assault in Massachusetts is an attempted battery, essentially. It made somebody afraid that they were going to be assaulted, as an assault in Massachusetts. So that was the question, is this use or attempted use of physical force? Does physical force mean offensive touching? And there are a number of states who have this definition where they talk about it's an offensive touch and not about pain. And the United States v. Castleman found that it does include offensive touching. And so that's what's included. Now, Minnesota, that would mean our domestic assault harm statute would qualify for federal firearm prohibitions. However, our domestic assault fear statute would not, because it doesn't include the definition, it doesn't meet that definition around physical force. This does not include a violation of an order for protection, because that's not a misdemeanor crime of domestic violence. Law enforcement and military personnel and other government employees are not exempt with respect to their ability to receive and possess firearms or ammunition. It is a complete prohibition. You've been convicted, there is no exception. And the conviction is, and the prohibition is for life. So who are you supposed to surrender the firearms to? So back in 2008, we had a Minnesota Court of Appeals case called State v. Romaine. And it said, well, this is back before Minnesota had its own specific firearm prohibitions as it related to orders for protection violations. And so there was an attempt to try to do this in a way of that the state can order under the state ordering under federal law that somebody have to forfeit their firearms. And what State v. Romaine said is that a state court can require a person to remain law-abiding, but they cannot rely on federal law to order the confiscation of firearms belonging to a person convicted of a violation of an order for protection. And that's 518B.01 subdivision 14B is an order for protection violation. So you can't try to circumvent federal law applies to you can only be prosecuted by the federal government. And so that's going to be your attorney, your USA, your United States attorney. And state law can only be prosecuted by the state, which is going to be your county prosecutors. So the two don't go together very well. And that's a very different conversation about the separation of federal and state law. And we're not going to go there today. Actually, I think we have a webinar on that about the differences if you ever want to check that out. So federal law, you have restraining orders and you have misdemeanor crimes of domestic violence. Restraining orders, the prohibition is in effect until the order is dismissed or expires. If you commit a crime of domestic violence, misdemeanor crime of domestic violence, it is that prohibition is forever unless there's something else that lifts it. There's a statutory authority for the restraining order and for the misdemeanor crime of domestic violence. There is an exception under restraining orders for law enforcement and military. There is no exception for a misdemeanor crime of domestic violence. There would be an exception under restraining order if there had not been a hearing, as would not be a hearing under 518B, and all ex parte orders. And under the misdemeanor crime of domestic violence, if the conviction was procedurally defective, or you get it expunged or set aside or pardoned, then firearm prohibitions might come back into play. All right, before we move on, so that's federal firearm prohibitions as it relates to domestic violence. Are there any questions before we move on to state? All right. So we had your Carrie when you used to host the show, Whose Line Is It Anyway? And it says, welcome to state court, where everything is made up and the rules don't matter. It is, I think there are plenty of you who are like, oh my gosh, this is so true. So love our state courts. Okay, so Minnesota. Some folks might remember when Minnesota firearm prohibitions as it relates to protective orders was passed. This is about, makes me feel old, maybe 10 years ago. Oh my gosh, was it really 10 years ago? It made an already fairly complicated landscape for firearm prohibitions even more complicated. So orders that have that are qualifying are orders for protection and domestic child abuse orders. And the reason they're qualifying is because we have specific statute that says that they are. There is no language in the harassment restraining order statute or the domestic abuse no contact order statute about firearm prohibitions. So there is now in the order of protection and the domestic abuse and the domestic child abuse. So those are the ones that could be qualifying. What makes them qualifying? First, you got to have particular language and prohibitions. And we'll talk about that in a second. You got to have notice and a hearing. Minnesota statute, it requires notice and a hearing. The language is a titch different under the domestic child abuse order, where it says actual notice and an opportunity to participate. Not sure what the difference between notice and actual notice is, but the word actual got in there. And then in 624.713, which is the firearm prohibition in general statute in Minnesota, where it lays out there's a lot of different folks beyond domestic violence that are not allowed to possess firearms, or are allowed to possess firearms. And that's the statute that lays that all out. It includes a piece of language saying that the respondent has to be informed of the surrender requirement. And I put a parens there, and I put a parens with a question mark there. And I'll talk a little bit about this later also, but one of the things that makes Minnesota firearm prohibition so very complicated is that under that 624.713, when those prohibitions for protective orders were put into place, the people who were doing that also codified under Minnesota law the federal requirements for firearm prohibitions. So they included the pieces of 922 that prohibit firearms in federal law, the stuff we just talked about. So federal law does not require that the respondent be informed of the surrender requirement. But Minnesota law does, and federal law has been incorporated into Minnesota law, like specifically says if you are prohibited from possessing under these two sections of federal law, you are prohibited from possessing in Minnesota. So now we have a conflict of language. We have no case law on this. No idea how this would play out. I guess it would depend on how the prosecutor charges the violation or of the possession is all I can assume. So this is part of the reason why firearm prohibitions are a little complicated in Minnesota. So that's why I have that question, that parens question mark, because I don't know. The language for qualifying is very similar to federal law. One from one category, one from the other. And does it restrain the abusing party of harassing, stalking, or threatening? Or does it restrain them from engaging in conduct that would place the petitioner in reasonable fear of bodily injury? Again, that no abuse provision as relief would qualify there. And does it do one of these other things? Include a finding that the party is a credible threat to the physical safety of the petitioner, or it prohibits the party from attempting to use, or threatening to use physical force. And again, the no abuse provision meets those parts of our qualifying language. So they're not entitled to possess, and again, some of the language gets additionally complicated. So the statute says under that language is order for protection. Okay. So then we move on to just in general under our 624.713 language that talks about firearm prohibitions and who can and who cannot possess. And so the statute says you shall not be entitled to possess ammunition or a pistol or a semi-automatic military style assault weapon or any other firearm, somebody who's been convicted of a crime of violence. Crime of violence has a very specific definition, and we will get to what that means in a second. But first, the question is, what's a firearm? Oddly enough, 624.713 does not define firearm. We have lots of definitions. We have definitions of pistols. We have definitions on semi-automatic military style assault weapons, but there is no definition of firearm. So there had been a case back in the 70s that defined firearm, and what that case said is it was anything that was shot with a projectile, that was shot that any sort of projectile removed from it. Sorry, I'm not it was using actually the definition of firearm from the DNR statutes, from the Department of Resources statute. And that meant like all sorts of things were a firearm. BB guns were a firearm. Paintball guns could be a firearm. A nail gun would be a firearm. Like it uses explosive force, right? And it uses force and air to push out a projectile. That could be considered a firearm. In 2016, Hayward went up to the Minnesota Supreme Court arguing, because in that case it was a BB gun with compressed air, and a felon who was caught possessing this BB gun was charged with possessing a firearm. They appealed it up to the Minnesota Supreme Court, and the Minnesota Supreme Court ultimately said, no, this definition from the 70s, that's way too broad. And so really it's a gun that discharges shot or projectile by means of explosive force and explosive combustion of gunpowder. Okay, so adding this kind of like gunpowder piece to it. And so what the court said then is it doesn't mean it's not a paintball gun and it's not a BB gun powered by compressed air. So folks who are prohibited from possessing a firearm, they can possess a paintball gun, they can possess a BB gun that's powered by compressed air, they can possess a nail gun. Then, so we had Hayward. Next, in 2020, we had Glover. And the question in that was, well, what's a weapon? Ultimately, so in this case, this was a distress flare launcher that technically is the flare is released into the air with gunpowder. Or explosive force. And the question was, is this a weapon? And again, we had a felon who was in possession of a distress flare launcher, maybe might have been used to scare somebody in a robbery. So then the question was, is this a weapon? And does a firearm need to be a weapon? And ultimately, the Minnesota Supreme Court in 2020 said a firearm, and when we're talking about prohibition, needs to be a weapon. And a weapon means an instrument that is used for attack or defense. And that means that a distress flare launcher is not a weapon. And there was some statement about there was some dicta from the court saying, well, who would ever use a flare launcher as a weapon? And I immediately went to Buffy the Vampire Slayer, and I am pretty sure Buffy or somebody used a flare launcher to light a vampire on fire to kill them. So I don't know. I guess the Minnesota Supreme Court just doesn't watch enough sci-fi to be able to have an imagination about the things that you could use a flare launcher for to hurt someone. But ultimately, the Minnesota Supreme Court said a distress flare launcher, not a weapon, therefore not a firearm for the points of prohibition. All right. So we do have a very strong definition of the word pistol. And I will not significantly bore you with it, but it becomes important because in Minnesota, we just don't ban people as it relates to all firearms, depending on the type of crime that somebody committed. They may be prohibited from possessing a pistol instead of all firearms, which means they can possess other firearms that are not defined as a pistol. And so here's the definition: fired by single hand, it's shorter than 26 inches, the barrel's less than 18 inches, and if it's less than 16 inches in the case of a rifle, then it has to be these other things, and it doesn't include a BB gun, scuba gun, a stun gun, and a nail gun, or children's pop guns or toys. So just making sure you know those aren't included in the definition of a pistol. So then what's a crime of violence, right? Remember I said that folks are prohibited from possessing if they've been convicted of a crime of violence. So a crime of violence is, this isn't an exhaustive list. The list, if you want to look at it, it's sub 5 and 624.712. The entire list of the crime of violence is, but the ones that we often mostly see when we're talking about domestic and sexual violence, we have the murder, manslaughter, assault, first to the 5th degree. What I will remind folks is that a crime of violence, sorry, I should have said this first, is a felony conviction. So you have to be convicted at the felony level. A gross misdemeanor or misdemeanor conviction of 5th degree assault does not qualify for firearm prohibitions as a crime of violence. If it's domestic assault, it will qualify under the domestic assault statutes as a prohibition, but it doesn't qualify as a crime of violence. So domestic assault, felony, domestic assault by strangulation, robbery at a felony level, kidnapping, false imprisonment. It also includes felony stalking. Oops, I still have terroristic threats, which has been called now threats of violence for quite a while. I just didn't update that slide. Sorry about that. Sex trafficking, crim sex in the 1st through the 4th degrees. Remember, 5th degree is a gross misdemeanor, not a felony. So here are examples of other crimes of violence. Somebody has been convicted of a crime of violence, a felony conviction. They are prohibited from possessing. All right, so remember when I said firearm prohibitions are really complicated in Minnesota? They're so complicated, I created a flowchart because there was no way for me to keep track of this any other way besides the flowchart. So I'm hoping you are looking at this on a big screen, big screen, so you can follow along. All right, let's see. I'm going to get my little pointer here. Hopefully this will help. So the first question is, are they prohibited from possessing by federal law? And if they are prohibited from possessing, and this is Minnesota firearm prohibitions, I want to be clear because that's what we're in Minnesota land here. We've talked about federal firearms, but remember how I told you that federal law was incorporated into Minnesota law. And so therefore, that's why we have this question. So is it prohibited by federal law? The answer is yes. Then they are prohibited from possessing a firearm for life. And then here's our statutory reference. If it is not prohibited by federal law, then the answer is no. The next question is, have they been convicted of a crime of violence? If the answer is yes, they are prohibited from life. And then here's our statutory reference. The answer is no. Then we get down to this very complicated. Then the first is, were they convicted of a crime of violence against a family or household member, or a crime against a family or household member? This is under 518B, talks about this. Convicted of a crime against a family or household member? If the answer is yes. Did they use a firearm? The answer is yes. Then that firearm itself must be forfeited. And then the person who was convicted may be prohibited from possessing a firearm for 3 years to life. Here's our statute. The answer is no, they did not use a firearm in the commission of that crime. They were prohibited from possessing a firearm from 3 years to life. Okay. If it is not a crime against a family or household member, then the next question is, were they convicted of assault within the last 3 years? The answer is yes. They are prohibited from possessing a pistol for 3 years. Remember I told you the whole definition of pistol was important? This is why. If the answer is no, they haven't been convicted of assault in the last 3 years, then there's no prohibition. They can possess a firearm. Has the person been convicted of stalking? If the answer is yes, did they use a firearm? The answer is yes. Then the firearm has to be forfeited and they're prohibited from possessing for 3 years to life. Maybe prohibited for 3 years to life. If the answer is no, they did not use a firearm, then they're prohibited from possessing a firearm for 3 years. Did they violate an order for protection? Did they use a firearm in that violation? If the answer is yes, again, firearm must be forfeited, and they are prohibited from possessing a firearm for 3 years to life. If the answer is no, then they're prohibited from possessing a pistol for 3 years. Okay, so we got that pistol language is back here when we're talking about order for protection violation. Now I will point out again that, yes, so pistol, right? Not going to point that out because that's not what it does. Order for protection in place, prohibited from possessing a firearm while the order is valid. We have Minnesota state law. We also got federal law that says that. This federal law up here, this is the misdemeanor crime of domestic violence, page 1. Harassment restraining order or violation of a harassment restraining order. No specific prohibition. DANCO or violation of a DANCO, but domestic abuse no contact order. No specific prohibition. All right. Feel free to make copies of this. Hand this to the special people in your life who may enjoy knowing these particular firearm prohibitions. Provide it to law enforcement, to prosecution. And also remember, this is not all the ways that one could be prohibited from possessing a firearm. These are just the ways that in domestic and sexual violence, we are often thinking about the way how folks are prohibited. Okay, Now that that is as clear as mud, what questions do folks have? I am so glad you love this chart, Janelle. You are welcome. Questions before we move on to kind of rendery stuff. All right, I know I'm an amazing presenter, and so clearly I have explained all the firearm things to the clarity that they deserve. All right, don't forget, you can always ask questions even if I move on, so keep typing away if you are. All right, so surrendering of firearms, this is a really sticky wicket, not only here in Minnesota, but even federally. The language in our statutes, both federal and state, talk about how the respondent or the defendant, depending on what thing is having them prohibited, is not allowed to possess a firearm or a pistol, depending on the circumstances in Minnesota. However, the statutes provide basically no direction on how surrender is supposed to happen, nor gives law enforcement any authority to like go bust into your house and take your guns if you have an order for protection, okay, against, for example. Law enforcement is super limited in what they can do because there's that whole pesky Fourth Amendment that doesn't allow illegal search and seizures, and they just don't have the statutory authority. It doesn't give them the right to do so. So getting firearms surrendered is a sticky wicket, to be fair. And it's not that law enforcement doesn't want to necessarily, maybe they don't, I don't know, but it's also like they're not statutorily allowed to. So law enforcement in Minnesota can accept firearms, and it's accepting. So somebody goes down to the police station to turn over a firearm. They can. Most law enforcement agencies do not in the state of Minnesota. There's a variety of reasons for that. Storage is definitely one of them. They don't want to be responsible for those things. There's a bunch of reasons. So often law enforcement is not in a position nor willing to accept firearms for if somebody is prohibited from possessing. If somebody is prohibited from possessing and they are thinking, or even if they're not prohibited and it's somebody else who possesses a firearm and they don't want to possess it anymore because it's a victim and it's their abuser's firearm and they don't want to have it in the house anymore. If you're thinking about bringing it to law enforcement, make sure to talk to them first. You do not want to walk into a police station with a firearm. Never a good idea if they're not expecting you. All right. So I don't want anybody to get set up to get hurt or to freak out law enforcement, because none of that's good. So I will say that under Minnesota law, if the district court, when they're issuing the order for protection, makes an imminent risk determination, which is a whole thing that I'm not going to go into that about, but if the court makes an imminent risk determination, then they are required to surrender to law enforcement. Law enforcement is required to accept. However, then law enforcement can transfer it to a FFL, which is a federally licensed firearm dealer, or to a third party. You can surrender them to law enforcement if they're accepting, or if there's an imminent risk determination through that order for protection. They can surrender to a federally licensed firearm dealer. They can surrender to a third party who does not reside with the respondent, by the way. So you can't surrender your firearm to somebody you live with if you're prohibited from possessing a firearm. And I would also remind folks that if you're going to surrender that, if you're going to give them to a third party to hold on to, that third party probably should be legally able to possess the firearm. Otherwise, you're just setting them up to be committing a crime. There will need, under orders for protection, the statute talks about how affidavits and proofs of transfer will be sealed. And that was negotiated language with the firearms folks there was concern about a firearm registry happening because of these. So affidavits and proof of transfer are sealed, or any affidavit of non-ownership, and that is also sealed. So some there has been, state court administration has created an affidavit and proof of transfer document to, for the respondent to fill out and to file. And so this is that document. And some courts are really pushing on making sure that this document is getting signed, especially if somebody is going to sign the document saying that they don't have any firearms. I'll remind folks that is signed under pains and penalties of perjury. So yep, somebody could lie, but if they got caught in their lie, then they've committed perjury and that's a crime and they could be prosecuted for it. So there is this document, but and then here's the second half of that document. This is the affidavit of no court ownership, that would also be sealed. The thing is that, again, whether somebody follows through with that or chooses to not follow through with that is difficult for the court to follow and to keep track of, because they've got a million cases, and quite honestly, it's not really the court's responsibility. So know that those forms are there, and know that often those forms are not filed. And so we'll talk about enforcement in a second. But my last meme is, you got, you know, cute little puppy in a suit and saying, feeling kind of cute, might get your motion denied later. I don't know. I want to stop and see if there are any questions about surrender and of firearms before we talk about enforcement of that surrender, about the process there. All right, hearing none. All right, so enforcement of surrender. We're talking about orders for protection and somebody not being able to possess a firearm while the order for protection is valid and in place. The truth is an order for protection is a civil order, and it is the petitioner's responsibility to make sure that the respondent either surrendered, that the respondent has filed the notice of transfer. And how do you do that? Things sealed. So here are our various ideas on that one. You request a review hearing, asking the court to review it, and then asking the court to see if there has that document has been filed. You could ask, and you know, seeing if that's been filed, you could ask the court in that process, could you tell me how many firearms are listed? If the petitioner knows how many firearms, and that would give them some clarity or some sense of relief that the firearms in fact have been surrendered. The petitioner could file a motion to unseal the affidavit and proof of transfer, explaining that it's just for them to be able to see, so that they know that, one, it was filed, and two, that all of the firearms were in fact listed on this affidavit and proof that they were transferred. If the petitioner knows that all the firearms have not been transferred, petitioner could file a motion for contempt. You know, explaining or asking that the court hold the respondent in contempt of court, civil contempt of court, maybe criminal, depending on the circumstances, for not complying with the surrender requirements. And then finally, this is actually when I train law enforcement, I always include this one. And when you're helping the respondent, if law enforcement's helping a respondent take their personal belongings, right? The order for protection allows the respondent to collect their personal belongings if they're not allowed to be in the home anymore. Don't help the respondent transport their firearms. Like, let's not do that. Let's leave the firearms in the shared home, and the respondent just goes. Don't help him be like, hey, you want to take this rifle with you? Let me help you put it in your car. So don't do that, because they're not allowed to possess anyway. So law enforcement shouldn't be helping people who are unable to possess. So those are ideas under an order for protection, because those are really only the civil options that exist for enforcing the order. If somebody has been convicted criminally if there's a criminal conviction, so they're prohibited from possessing because they've been convicted of a misdemeanor crime of domestic violence, or they've been convicted of a crime of violence, or they've been convicted of a violation of an order for protection. If for some reason they are under probation or some sort of supervised release, when you're under court jurisdiction, you have different rights as it relates to the Fourth Amendment, and to the right to unauthorized search and seizure. And probation often has the ability to be able to go in and do a search. So is it talking with law enforcement and probation and helping them understand that you believe that that there's law enforcement out there, or that there are firearms, and having them go in and look and see what they might be able to find. And then finally, another option is law enforcement can get a warrant. Like, yes, they can't, law enforcement isn't able to enter a house unreasonably, but they can do so with a warrant. And if there can be probable cause of an argument that the respondent is possessing a firearm when they are not allowed to under Minnesota or federal law to possess a firearm, then law enforcement can get a warrant and go in and search for the firearms. So, those are the options that exist when talking about enforcing that surrender. Who decides where and to whom a firearm is surrendered? That's a really good question, Raylene. The truth is that except for in that imminent piece, let me go back to that language. Except for that imminent risk, it's the offender who gets to decide who they're going to, or the respondent who gets to decide who they're going to surrender it to. They want to surrender it to, they can try to surrender it to law enforcement if law enforcement's accepting, but most of the time it's their choice to decide whether they're going to surrender to a firearms dealer or a federally licensed firearm dealer or a third party. It's totally up to them. So they can give it to their brother if they don't live with their brother and their brother is legally able to possess, who may very well just turn around in 3 days and give it back. I understand that this is not a perfect system, right? Not at all. But a good question, really. What other questions do folks have? That's where I'm at. So all the questions, this is your chance. This is it. Never answer any of your other firearm questions again. I'm just kidding. I'll answer all your firearm questions. I love them. What questions do folks have? All right.
Well, I think everything is clear, Rena.
Basically, state law, complicated, and conflict between federal and state law is, did I talk about, Anna Maria, did I talk about how state law does not, I did not, state law does not have the exemption for law enforcement and military personnel on order to protection?
I think you did.
I did bring that up. I can't remember because we had a conversation about it at work, and now I can't remember if I said it here. If I'm just going to say it again because I got a few minutes and you have me until 3. So in case I didn't say this, while federal law has an exemption for law enforcement and military personnel to continue to possess their service weapon, Minnesota law does not have that exemption. Like I said, federal law as it relates to these things has been incorporated into Minnesota law. So we have another conflict in our laws where Minnesota law does not provide any language for an exception for law enforcement or military if there is an order for protection and they are the respondent for them to be able to possess a firearm, but federal law does. So again, I have no case law on this, so I have no idea how this would play out, on which law would trump or would win out the day in this case, but there is a conflict there. Okay.
I don't see any other questions. Obviously we have our contact info. Oh, yep.
Okay. Someone says that they've had a situation where the respondent's child had a firearm and the respondent was a felon and not supposed to have a firearm. Officer could not determine if the gun in the picture the petitioner had was a BB gun and added it was not going to violate him on a firearms condition. I mean, you know, law enforcement has a lot of discretion. You know, there is a little bit of case law about what does possession mean, and I wish there was more. I think, you know, some of the cases around possession talk about like, and I mean possession of a firearm, not possession of other things, but possession of a firearm. Most of them talk about your ability to have access to it and knowing that it's there and an ability to have access to it. So if the respondent's child lives in the respondent's home and the firearm is not locked up or in a place that the respondent cannot get access to it, I would argue that's possession. That's me, and we all know that I have different opinions than other folks who may be working within the criminal justice system. And if they can't determine if it's a BB gun or not, you know, I mean, you can always go over and ask, but if they're not going to violate, then they're not going to violate. So I can understand the frustration on that one. What if the petitioner lives in Minnesota and the respondent is out of state? Then it would be the out of state's laws about possession and federal law about possession, because unless they come into Minnesota possessing a firearm, and then it would be Minnesota laws about possession. So you violate the law where you live, except unless you're calling somebody across state lines, and then you're violating cross state lines, but that's a different story. But in this circumstance, it would be where the respondent lives, unless they come into, and are they violating that state's laws? Yep, it's a good question. All right. Other questions? These are all great. Oh, that's frustrating, Leona.
All right, if there are no more questions, I will now end the webinar. Thanks everyone for attending, and thank you to Rana and Ana Maria.
Absolutely. Thank you, everybody. Have a great rest of your day. Happy
Thank
Thanksgiving
you.
to those who
Stay
celebrate.
warm. Yeah, see you all next month.